But overall, I just wanted to get your take, your feeling on whether this is a sweetheart deal, right? It's been called that by a lot of Republicans reacting. I know that there have been gun rights groups that have been unhappy with this situation as well. Do you feel like, let's just start with the specific things he's agreeing to and the charges that were brought. Because there's obviously one part of this is like what was charged and whether the punishment for that is fair, and
right.
what wasn't charged, and these other things that Hunter Biden has done that people, or at least he's been accused of doing, that aren't involved in this particular plea agreement. So let's just start with what he was charged with. Do you think this outcome, this deal that he struck, from what we know of it, is a fair one?
So in terms of what he's having to plead guilty to, the 2 misdemeanor counts for failing to file a return, my answer is yes. This is a relatively normal pre-indictment disposition. You're going to get a little better deal if you don't make them indict you, and you in effect agree before even being charged to plead guilty. He could hypothetically be charged more harshly with a felony of tax evasion. But practically speaking, that's hard to prove. That's not just willfully failing to file a return. It's basically having an intent to deceive the government. And usually you have to do something affirmative, like file a false document or hide assets or something like that. And if you're just like in a cocaine haze for a couple of years and you don't file anything, that's not really tax evasion. It's also a tough charge to make, the more serious felony of tax evasion, because an incorrect belief about what the law is a defense, even if it's completely unreasonable. So if Hunter Biden thinks dudes on crack don't have to file taxes, if he thinks that sincerely, even if it's completely stupid, then that's not tax evasion. So that's how Wesley Snipes got off the hook on his felony tax charges, most likely.
Yeah. So Chris, I don't know much about the tax side of it,
right.
So I can't ask you too many follow-ups there. But the gun charge, this is my understanding, and from my reporting over the last couple of years following this case, I've spoken with Professor Drew Stevenson, who has written about this specific charge. This is about people who are drug users that own guns. Anyone who's a drug user and owns guns is a felon under federal law. And usually you see this crop up with things like medical marijuana being legalized in a lot of states and how that interacts with federal law, where it's still illegal and still implicates this prohibition. But as far as Professor Stevenson says, this is a pretty uncommon charge as a standalone charge. And what I mean by standalone charge, because obviously he pled to 2 other charges, but they don't have anything to do with the gun purchase. The stuff surrounding the gun is just this one charge of him being a drug user and possessing firearms.
Right. So it is extremely rare.
He said there's only about 200 convictions a year where that's the only charge.
I would be surprised if it's that high, frankly.
Well, I would say one point of context, just real quick on that, is he did tell me that is where there's a conviction, which means that his belief there were probably other charges before. That basically the way this gets used in practice, and we'll talk about some specific examples later, but is that it's a tack-on charge. It's something that you add when there's a more serious either drug crime or gun crime involved, and it's either enhances the sentence that the suspect gets, or it can be used as a fallback, basically. If it's harder to prove the other crimes, if you catch someone with, a pound of meth in their car and a loaded gun, maybe you can charge them with a higher level drug crime, whether it's as a trafficker or a dealer, but you can also charge them with just this possession crime, right?
Yeah, exactly. So it's a crime that you almost never see in isolation, not connected to something else. So it's the type of crime that, like you said, is just like kitchen sink charging, where we're going to get this person for every single thing we can find, or it's something you charge when you can't find another charge, but you really don't like the person. And so the case you brought up is that case where they charged the mom with this when the young kid took the gun into school and a teacher was accidentally shot. That's a classic example of we're going to cast around to find something we can charge this person with. But it's I mean, in America right now, I think the statistics I saw most recently are they estimate around 60 million people have used illegal drugs or abused prescription drugs in any given year. And a lot of those people own guns. And, no significant portion of them are getting charged, nor is there any serious effort to charge any significant part of them. So this is something about federal law that a lot of people don't realize it's a little scary, is that there are all sorts of extremely broad, extremely flexible laws that huge groups of Americans are technically guilty of that they can use against you if you want. So that's not a good thing in my view as a criminal defense attorney. But here, the types of situations where you see this charged are, for instance, when they're doing sort of task force actions or sweeps, we're going to bring in the feds to help us take out all the gang members in this town. A few of them get arrested and this is the only thing they can find to charge them with. It gets charged like that. It gets charged when, like you said, they take down someone for a bunch of other things and the federal prosecutor's pissed, so they throw this in too on top of everything else. Sometimes it gets charged as a vehicle to charge someone something more lenient if they're extenuating circumstances. But it's a really uncommon charge. I never saw it in the 6 years I was a federal prosecutor. I haven't seen it as a defense attorney, and it's only in unusual circumstances.
Okay.
The other thing to note about it, Stephen, is that it's relatively lenient in terms of punishment. So I've seen a lot of people claim, well, when the government comes after my gun clients, they come and they do years in prison.
Yeah,
well, that's because they're being charged with different things.
Right. Is that basically this charge, in theory, could carry up to 10 years in prison with it, and Biden is getting a pretrial diversion program that features no prison time at all. But how does that comport with how this is usually handled?
It doesn't at all. So federal sentencing, the maximum sentence is rarely relevant. The way the sentence is determined is under a system called the Federal Sentencing Guidelines, which is an extremely, some would say, needlessly complex and geeky set of formulas and numbers. Depending on how geeky you are, it's either like filling out a tax return for a mid-sized business or like creating a second edition Dungeons and Dragons character. And under those guidelines, this particular crime of being an addict in possession of a gun has a recommended sentence that's quite low. In looking at the guidelines to prepare for this today, my read of it is someone without a criminal history who, was just an addict in possession of the gun. The recommended range would be 10 to 16 months. The judge would have discretion to go lower than that. And even if the judge were being a stickler, it's in a zone of the guidelines where you can do half of that in a halfway house and half in prison. So the idea that this crime typically gets a lot of time is just not right. Okay.
But what about the pretrial diversion program being used here? Is that a sweetheart thing for Biden in particular, or in someone in the same circumstance who's pleading to 2 misdemeanors and this particular gun crime, are they going to get that same treatment?
I don't see it as a sweetheart deal for him, and here's why. He's pleading to 2 federal tax misdemeanors in a way that someone in his circumstance would typically do. We're hearing reporting that they've promised to recommend probation. We don't know if that's true or not. I'm a little skeptical. That would be fairly lenient if it's true, because the guidelines would seem to be a little higher than that. But it's the judge who makes that call, what sentence he gets. But the thing is that if it were anyone but Hunter Biden, then I don't think they'd be making him do anything with a gun charge. The only reason they're been dropped, or yeah, it wouldn't have been pursued at all. The only reason they're doing it is the man went and basically boasted about it in a published autobiography, which as a defense lawyer, I'm going to ask you all out there not to do. And second of all, because he's Hunter Biden and they're bending over backwards not to seem like they're cutting him some sort of deal. So I think if it were my clients, a relatively obscure person, and in the course of the tax investigation, they learned that at some point he was doing crack and he had a gun, I don't have any concern that they would charge that.